Good afternoon, everyone. Thank you all for cooperating with this manner of hearing. And we're now going to call on Mr. Perry for the respondent. Mr. Perry.
Thank you very much, my Lord. My Lord, may I just deal with one preliminary point? Mr. Boulel, Senior Counsel, the Director of Public Prosecutions, is also present, and as your Lordships know, his name appears on our pleading at bundle page 1043, and it's right to acknowledge his presence and the contribution he's made to the respondent's case. That's simply for the record.
Thank you very much indeed, and welcome, Mr. Boulel, to the hearing, and you're plainly visible, I'm glad to say.
Thank you very much, my Lord. My Lord, I will adopt without repeating the written argument set out in our written case, which for the board's note is record 1010 to 1043, and begin by making some preliminary remarks in relation to the context of the case overall. The first point that we would make is that tax legislation is designed to impose and relieve tax on transactions that take place in the real world. The Ramsey principle is concerned with identifying what is to be regarded as the real transaction. And the importance of the authorities from Ramsey onwards is that the transaction is to be looked at as a whole, in context and realistically. The sequence of cases put an end to what was described by the House of Lords as the vice of formalism, and moved away from an insistence on examining steps in a composite scheme separately. The key point in this appeal is that if the legislature in Mauritius granted a relief from tax, it was clearly intended that that relief should be available for something that had a purpose other than generating the relief in question. It certainly did not intend that it should benefit a person who was not entitled to the relief. In other words, a key consideration for the Intermediate Court was whether the excise duty relief scheme that confronted it was a sham. In this case, we submit the Supreme Court was right to conclude that the returning resident scheme was not intended to benefit non-qualifying residents. Had the magistrate looked at the scheme as a whole, a quite different picture would or might have emerged. We also submit that the Supreme Court was also right to quash the verdict and order a retrial. For your Lordship's note, the amount of excise duty evaded was just short of £160,000. And there was real public disquiet in Mauritius, as evidenced by the media articles which are to be found in your Lordship's bundles at pages 432 to 439. The public disquiet was that the scheme was being abused by wealthy Mauritians to the detriment of the public exchequer. The fundamental error on the part of the magistrate was not to approach the importation scheme by looking at it globally and failing to discern what was the true intention of the parties involved in the scheme. And if I may just very briefly summarize some of the material facts which may assist your Lordships when it comes to considering the judgment, dealing first of all with Mr. Seeburrun. As your Lordships have already noted, he was a self-employed teacher by the time he returned to Mauritius, in his mid-30s at the time of the events in question. His date of birth was the 6th of April 1979, and he returned to Mauritius from the United Kingdom on the 5th of November 2010, just 2 months or so before the importation. He had spent approximately 7 years in the United Kingdom, where he worked as a station assistant for Transport for London. That can be seen, I won't turn it up, but just for your lordship's note, see page 477 of the bundle for his curriculum vitae. He had originally left Mauritius in August 2003, and there is in your lordship's bundle an idea of the salary he was earning during his employment in the United Kingdom in the tax years to April. Page 506 of the bundle for tax year 2006, just over £20,000. And by the time he left, there are also 2007, page 507, 21,000, 2008, page 508 of the bundle, 22,000, 2009, page 510, 28,000, and in 2010 to April, 29,000 at page 511. In the final part of his tax year, before his departure in 2010, that's April to November, he received £15,400 odd. And according to his curriculum vitae at page 479, when he returned to Mauritius, he was seeking work and offered a great deal of commitment to any employer and was willing to learn. It is not apparent that he was in paid employment immediately on his return to Mauritius. Yet, within 2 months of his return, he was involved in importing into Mauritius a high-value Mercedes-Benz motor car, which had been bought at a cost of over £143,000. That figure takes no account of the shipping costs and other expenses, which I will come on to identify for your lordships in a moment. We also have Mr. Seeburrun's bank account statements following his return to Mauritius. They're in your lordship's bundles at page 450 to 464, which shows some incoming payments of around £800 a month. There is, moreover, no evidence that prior to his return to Mauritius, he was an associate or friend of Mr. Lagesse, nor is there any evidence that Mr. Seeburrun had need of a motor car costing £143,000, as indeed he did not, because we know that immediately upon its importation into Mauritius, it was made available to Mr. Lagesse for his exclusive use. Mr. Lagesse, on the other hand, is a well-known businessman in Mauritius, aged 58 at the time of the importation, and he provided the funding for the Mercedes-Benz motor car with payments made directly to the car dealership. So it was not a loan to Mr. Seeburrun. The payments were made directly to the car dealerships involved. Your lordships can see that by looking at the payment debit notes in the bundle at page 427 and page 428. There were payments of 25,000 at the end of December 2010, 90,000 in early January, 28,000 odd on the 10th of January, making a total of 143,500. That having been paid to the dealers, the car was imported into Mauritius by Mr. Toolsey, the third defendant in the intermediate court proceedings, on the 21st of February 2011. But one of the curiosities amongst the documentation before the intermediate court, which the magistrate did not address, is that there was a new vehicle invoice from Bramley's, a car dealership, page 494 of your lordship's bundle, which suggested that the purchase price of the car had been £70,582 and that that sum had been received directly from Mr. Seeburrun. That was one of only several curiosities in the documentation. Apart from two photographs, which are in your Lordship's bundles at page 472 and 473, there is no evidence that the motor vehicle was ever in the possession of Mr. Seeburrun. The evidence before the lower court was that it had at all times been in the possession of Mr. Lagesse. And in fact, Mr. Lagesse admitted, see the record at page 416, that he'd been allowed by Mr. Seeburrun to have the use of it.
Lord Jones.
Breaking up, and I'm missing some words of council submissions.
I'm very sorry, my lord. I'm very sorry, my lord.
Yeah, I can hear you perfectly well. Lord Sales.
Just on the point of fact, whether there was evidence that the car was ever in the possession of the second appellant, we were taken to page 325 of the bundle, the part of the magistrate's decision dealing with count 5, I think it was, where it seems that the prosecution accepted that accused number 2 did take possession of the car. What do you say about that?
My lord, it was clearly the case that it was in his possession for a very short period of time, because what had happened was, following its importation, it appears as though he'd taken it to his home, and the two photographs that were taken were photographs taken with the car at his garage at his home. But I'll take your lordships in a moment to the way the prosecution were putting the case before the intermediate court, because it's quite clear that the case that was being presented was that the scheme looked at overall was indeed a sham. So on the facts, my lord, it was also apparent, or on these facts, it was apparent that Mr. Seeburrun did not have the means to buy such a car. And there is also a statement of assets and liabilities in relation to Mr. Seeburrun, which can be seen in the record at page 474. And the obvious question raised by the prosecution case were, why would Mr. Seeburrun, who did not have the money to pay for such a vehicle, buy such an expensive car, which he then did not use, but parted with, so that Mr. Lagesse was allowed its exclusive use? But the evidence went further than this, because it is also the case that Mr. Lagesse paid for the insurance on the vehicle from the time of its importation. The certificate of insurance in relation to the importation is in your lordship's bundle at page 481. And he also paid for the road insurance for the period from the 18th of February through to June 2010 through to the 30th of June 2013, which can be seen by the documents in the record. Page 521 is an invoice addressed to Mr. Seeburrun by the insurers in the amount of 118,000 rupees, which is about £2,388, but it was paid for by Mr. Lagesse. And it was addressed to Mr. Seeburrun at Mr. Lagesse's commercial premises. Page 539 is the next invoice for the period 1st of July 2011 to the 1st of July 2012. This time it's addressed to Mr. Lagesse, not Mr. Seeburrun, and the amount is 323,000 odd rupees, which is about £6,500. Page 543, another invoice, 316,000 rupees, approximately £6,400. So Mr. Seeburrun was also importing a car he couldn't afford, and Mr. Lagesse was expending considerable amounts on insurance premiums way beyond anything that, again, that Mr. Seeburrun could afford. We can also see from the document, and if I may just take your lordships to this document at page 483 of the record, there is an email. It's the email in the middle of the page from the third defendant, Mr. Toolsey. It's sent on the 17th of February 2011, so just a week or so before the importation. And Mr. Toolsey is sending this to the insurance brokers, and the subject is the details for the vehicle of Mr. Lagesse. And Mr. Toolsey says, as per our phone conversation, please find below details for the airplane of Mr. Lagesse. And then there's also Mr. Seeburrun's name. The reference to airplane is readily understandable by considering the photographs of the vehicle, which your lordships will have seen at page 336 to 337. We then have, if I may just go to the lease agreement, which is page 465, the French version, and 843, the English version. And the points to note in relation.
Sorry, yes, I think we're all having trouble with the sound.
I'm sorry, my lord.
That's all right, you're back again.
I'm sorry.
You did not apologize, Mr. Perry. Everybody is to blame, it is not you.
Well, thank you very much.
Mr. Perry again.
My lord,
Mr. Perry, we lost you at the point to note, therefore didn't note the point.
Oh, I think the point to note, I dealt with the airplane for Mr. Lagesse, yes, and that was the photographs. The point to note about the lease agreement is the amount involved, which Mr. Seeburrun has acknowledged as being indebted to Mr. Lagesse for, because it is inconsistent with what later appears in the acknowledgement of debt. So if I may just invite your lordship's attention to page 843, your lordships can see from the lease agreement, it first of all identifies the parties, Mr. Seeburrun as the lessor, Mr. Lagesse's management, but acting through him as the lessee, and then it says that Mr. Seeburrun is the owner of the motor car. And then it says, your lordships will see which car had been acquired by means of a loan of 11 million rupees. That is about £220,000. It's way in excess of the price of the purchase price of the motor vehicle. But Mr. Seeburrun appears to be accepting that that is what his indebtedness is. Then it says the lessee is desirous, that's Mr. Lagesse, of renting the car with an option of purchase. Then your lordships will see at the bottom of the page, it just so happens that the lease is for a period of 4 years, which is the period of time that has to elapse before someone can dispose of a car without incurring a penalty under the scheme. Then, just going over the page to 844, your lordships will see that Mr. Seeburrun is conferring on Mr. Lagesse the option to purchase the vehicle at the expiry of that period for a value of 100,000 rupees, which is about £2,000 odd. And there are various recitals. Then the rent at bottom of 844 is 300,000 rupees, which is about £6,000 odd. And then 845 are the obligations of the lessor. That's Mr. Seeburrun shall assure the lessee, Mr. Lagesse, of the peaceful enjoyment of the property. Then the obligations of the lessee, which is to pay the taxes and duties and costs and maintenance. And then your lordships will see the termination provision. The present lease shall be terminated only at the expiry of its term. In no case shall the lessor, that's Mr. Seeburrun, terminate it except with the express consent of the lessee. Now, what is the background to this document? The background is this. In Mr. Seeburrun's affidavit, which your lordships will find at page 442, I wasn't proposing to turn to it, but in Mr. Seeburrun's affidavit, dated the 17th of May 2013, he said that he had signed this lease agreement on the 17th of February 2011, which is the same date that Mr. Toolsey is sending the email about Mr. Lagesse's airplane, but he did not explain why he had signed a lease agreement making reference to a loan of 11 million rupees. He said, however, that it had been replaced by the acknowledgement of debt dated the 19th of February, which we can see in the French at page 408, but in the English at page 820. And at 820, we can see that Mr. Seeburrun signed an acknowledgement of debt that he owed Mr. Lagesse the sum of 6.8 million rupees, which is 143,500. That's the purchase price of the car. And he undertook to reimburse him without interest on the 25th of February 2015. So that would be immediately after the expiry of the 4-year period. And that is dated 2 days after Mr. Seeburrun said he'd signed the lease agreement. No explanation as to why it was that the figure has changed from 11 million to 6.8. Nor does that figure correspond with Mr. Seeburrun's statement of assets and liabilities. If I may just give your lordships the reference, page 474, he prepared a statement of assets and liabilities where the loan is given as just over 7 million rupees. So we have in the documentation before the intermediate court 3 different figures. Mr. Seeburrun made another affidavit dated the 11th of February 2013, in which that's page 446, in which he said he'd allowed Mr. Lagesse to drive the car for recreational and professional purposes. It is also the case that Mr. Lagesse swore an affidavit on the 8th of March 2013. This was in the impounding proceedings, which is in the record at page 416, in which he said that the car had been let to him by Mr. Seeburrun. That was the word he used. That was then later corrected in an affidavit dated the 21st of June 2013 to lent to him, see page 420, and he denied entering into a lease agreement and said that he'd been allowed to have the use of the car by Mr. Seeburrun. Of course, it's fair to acknowledge that Mr. Lagesse did not sign the lease agreement, but the documents in themselves are certainly not suggestive of a legitimate use of the returning resident scheme, and as the Supreme Court put it, this was a case in which the circumstances needed to be thoroughly analysed. It is also of interest to note that in his affidavit dated the 28th of March 2013, Mr. Lagesse said that the car was the property of Mr. Seeburrun, as evidenced by the insurance certificate, see page 418, although it's apparent that Mr. Lagesse was in fact meeting the insurance payments. Also of significance for your lordships, which is not apparent from the magistrate's court judgment, from the magistrate's judgment in the intermediate court, is what Mr. Lagesse said in his caution statement dated the 27th of August 2013, which is, for your lordship's note, page 368 of the bundle. The point that I'm going to make is that the 143,500 figure of the purchase price was only part of the cost incurred in bringing the vehicle into Mauritius, because Mr. Lagesse in his caution statement said that in addition to the payments of 143,500, which represented the cost of the car in the United Kingdom, he'd also made payments amounting to in excess of £43,000. He produced 3 cheques totaling over 2 million rupees, and those cheques, the 2 million rupees odd, covered the costs of the vehicle's clearance through customs and other expenses. Just again, perhaps I could just go to to page 492 to make another point about the documentation. If I may just invite your lordships to page 492. This is the Mauritius Customs Single Goods Declaration form, and your lordships will see that the value of the vehicle was declared. It's just over halfway down on the right hand side of the page. I hope your lordships can see the figure 70,000 GBP. 70,000 GBP. The value of the vehicle being declared to the customs authorities in Mauritius was £70,000, not 143,000. And that is significant because that value was relevant to the calculation of the figure of the duty that was in fact payable, which your lordships can see in the bottom right-hand corner of that document, which is the 1,114,211 rupees, which is £22,000. So Mr. Lagesse was paying duty on a vehicle declared to be valued at £70,000, and he was meeting the costs, although the excise duty, of course, was zero, because Mr. Seeburrun purported to take advantage of the returning resident scheme. The point is, the documentation is suggestive of a sham. Mr. Seeburrun is not making any payments whatsoever in relation to the vehicle. He's becoming enormously indebted for an amount he cannot conceivably repay, and he could not in any event have afforded to import this car and keep it on the road. The prosecution case was simple. The use of Mr. Seeburrun was designed to enable Mr. Lagesse to obtain an expensive vehicle with the benefit of a tax exemption to which he was not entitled. And this expression of the prosecution case can be seen most clearly at page 256 of your lordship's bundle, where this is in the submissions before the lower court. In the closing submissions, after the evidence had been given. And the clear case that was being put, your lordships will see, was that Mr. Seeburrun had no role to play except his name was being used. And if his name is being used, his name is being used precisely to evade the payment of customs duties. So Mr. Seeburrun, his name is only being used. He didn't buy the car when he was in the UK. Then there's a reference to the payments, customs, insurance, registration. And then in the paragraph which makes it clear, the second paragraph, that the promissory note was a smoke screen. It says smoke script, that should be smoke screen. And all the evidence, the final part of that section, just above line 30, points to the fact the vehicle was brought into the sole enjoyment of Mr. Lagesse, and Mr. Seeburrun, his name was used as a prête nom. In other words, the true beneficial owner of the vehicle was Mr. Lagesse. Mr. Seeburrun was simply a prête nom. Now, the way the defence case was put before the intermediate court can be seen most clearly at page 268, where in their closing submissions, the leading counsel on behalf of Mr. Lagesse at page 268, just above line 40, deals with the component parts of the scheme and says, I'm afraid it's not illegal in Mauritius. It is not illegal in Mauritius for anyone to help or finance someone else in order for that person to benefit from something which is allowed under the law. The financing part of Mr. Lagesse to Mr. Seeburrun is not unlawful. The importation of Mr. Seeburrun of the car, having satisfied the conditions of the law, is not an unlawful act. So what only remains is the use of the car or the possession of the car. That was an attempt to break down the transaction into its component parts so that the defence would be left at the end of the case to say, if you put your blinkers on and you say, you ask the question, is Mr. Seeburrun entitled to the returning resident exemption? Yes. Was it unlawful for Mr. Lagesse to fund the vehicle for Mr. Seeburrun? No. Was it unlawful for Mr. Seeburrun then to let Mr. Lagesse have the use of it? No. But that fundamentally ignores what was at the very heart of this case, namely, was this agreement, this transaction, a sham? Because when you look at the facts, that is what it is suggestive of. The scheme devised by the appellants provided no benefit to Seeburrun whatsoever. In fact, it lumbered him with an enormous debt. As a returning resident, he imported a car he did not want. And Mr. Lagesse, on the other hand, had the exclusive use of a vehicle he did want. This only makes sense if it was in truth Mr. Lagesse's car. The transaction purported to be something it was not. The magistrate's ruling simply does not grapple with this aspect of the prosecution case. And his discussion of the case begins at page 315. The points to note at page 315 are the magistrate proceeds on the basis of what each of the accused had admitted. But that was not the prosecution or the respondents in this appeal submit should not have been taken at face value, as the magistrate appeared to deal with it. he deals with the various accused and what they had admitted on page 315. And he deals with the payments made by Mr. Lagesse. He doesn't deal with the other payments on the importation of the car. He simply deals with the purchase price and the insurance. And he says, in relation to Mr. Seeburrun at line 30, thus there is no doubt that accused number 2 was the importer of the said car. That's because he was shown as the consignee, and claimed duty concession as a returning citizen. And those facts had been confirmed in his affidavit. Then at page 317, at the bottom of the page, having dealt with the agreement aspect of conspiracy, it can reasonably be inferred, just above line 40, there was an agreement between the 3 accused parties for accused number 2 to import a car to be ordered by accused number 3 by using the returning resident status and thereby benefiting from concessionary rates on duties. And the purchase of the car would be financed by accused number 1, who would then be allowed by accused number 2 to use and have possession of the said car in return. That doesn't grapple with the overall ownership and purpose of the scheme. And the magistrate then fell into the trap with respect of looking at each of the component parts separately. And your lordships will see that on page 318 at 30, he then says, had the agreement been that accused number 1 imported the car and claimed this concession, then there would be an offence. But that's effectively the substance of the prosecution case. And then at 319, just below line 30, there is no evidence whatsoever that accused number 2 failed to comply with the conditions once he was granted the concession. He is still the rightful owner. Well, that begs the very question that fell to be determined. And the magistrate
sorry, Lord Sales.
I'm sorry.
Yes, Mr. Perry, you say that begs the question. I think that we were told by other counsel that the prosecution accepted that the second appellant was in fact the owner of the car in the course of the trial, and that in fact there was a shift in the prosecution case between trial, where it was a question of second appellant is owner but then disposes the first appellant, and the case being advanced on the appeal where it was being said first appellant was the real owner throughout. Can you help us with that?
Yes, my lord, I don't accept there was a shift in case, because it was always put on the basis that Seeburrun was the pret nom. And I'll come on to deal with the submission made before the Supreme Court, my lord, but the position before the Supreme Court was that the arrangement was a sham, that it was a disguise, a smokescreen, as prosecuting counsel had put it. And also, it was put before the Supreme Court, and I'll take your lordships to this in a moment, if I may, that the question of disposal simply did not arise. That was the point that was being made. The question of disposal didn't arise because it had never been, in reality, Mr. Seeburrun's vehicle. And the point that was being made, and if I may just conclude with the magistrates,
Thank you.
The magistrate dealt with the lease agreement at 321 at the top of the page. True it is, when lease agreement is considered, and then he says it was never countersigned, but he doesn't address the curiosity of the amount. And then at the bottom of page 321, there's definitely no evidence of let or lease as a means of otherwise dispose of. And then he refers at 322 to the case of Seeburrun, in which the Supreme Court of Mauritius had considered the mens rea of conspiracy. And your lordships will see that it sets out pretty uncontroversial general principles of conspiracy law. And then the learned magistrate at the top of page 323 underlines and emphasizes part of the judgment which was irrelevant. If on the facts known to them what they agreed to do was lawful, they are not rendered artificially guilty by the existence of other facts not known to them, giving a different and criminal quality to the act agreed upon. That was not this case. What was this case is the next section, which he did not emphasize. The prosecution are not bound to prove that the persons entering into the agreement had knowledge of the illegality of the act agreed to be done. As to both that and the necessity of proving knowledge of essential facts, see, and there's reference to the well-known case of Churchill and Walton. But this was not a case where the defendants were saying there were facts unknown to us which would have rendered this innocent. This was a case where the prosecution was saying they've entered into this agreement, and the agreement they've entered into renders them guilty of the charge. And because the magistrate found that the case against all three parties had not been proved, he then dismissed the charge under count 2, which was the possession and liability for the excise duty. In summary, our submissions are: the magistrate's finding is unsustainable. By adopting a literal approach to the legislation, he effectively found that Mr. Lagesse was to benefit from a concession to which he was not entitled, and that Mr. Seeburrun had a concession from which he was not to benefit. These are the classic indicia of shams, and the whole scheme was called into question. In the appeal proceedings, and this deals with the points that have been raised in argument, at page 329, your lordships will see the notice of appeal. And the purpose of referring to this is to invite your lordship's attention to the prayer for relief, because your lordships will see that in the preamble of the notice, just before it comes on to the substantive grounds, that the prayer for relief was that the Supreme Court should quash, reverse, set aside, amend, or otherwise deal with the case as the Supreme Court shall deem fit and proper. And then the grounds of appeal, there's the wrong in law for the evasion of the parties, which made it clear the importation was of a car in the name of accused number 2, and Mr. Lagesse had incurred all the expenses. And there were also, in ground 4, ground 2 dealt with the exclusion of Mr. Tools's statements, even though there'd been no argument they should be excluded. A was later deleted, but 4A, that it was solely designed to circumvent the law by evading payment of duties and allow accused number 1 to benefit from a concession to which he was not entitled. The notice for lodging an appeal is also at page 557. That was the earlier notice, and then this is the notice for lodging an appeal, as opposed to the earlier document. And your lordships will see again the same prayer for relief, the same points being taken. There is a notice, one of these notices of appeal, in the case of each of the defendants. Your lordships can see, for example, a notice of appeal at 564, and the director's skeleton is at page 585 to 595. And your lordships will recall that before the argument, before the oral argument before the Supreme Court justices made clear that they'd read the parties' submissions. And this was the director's skeleton. And at page 586, your lordships will see at paragraph 4, it will be submitted that the learned magistrate took a narrow and unjustified view that the importation was an isolated element out of the context of the overall scheme and against the intent and purpose of the parties, in contrast to the initial observation above. And then, paragraph 5, it was made clear in using the same words that had been put to the magistrate, to which I'd made reference earlier. The appellant will submit that the agreement was to import the car for the eventual benefit of respondent number 1, who financed and purchased it and was found in possession. Accused number 2 did not have anything to do with the car, apart from signing the documents with the Mauritius Revenue Authority.
Sorry, we seem to have lost you.
Sorry, my lord.
Yes, we've got you again. Could you just recapitulate on the last few sentences, please?
Yes, my lord. In paragraph 5, my lord, the appellant submission was effectively Mr. Seeburrun's name had been used, and that was it. That was all. That the only part he played was his name. And your lordships will see at the top of page 587 that the reconnaissance des dettes and the alleged lease were devised as smoke screens to dupe the authorities. Number 2, respondent number 2, Mr. Seeburrun, was used as a prétendant. Respondent number 2 is owner only on paper, and all the rights on the car was exercised by respondent number 1. The car was imported in the name of respondent, but in light of all the facts, it was not sustainable to make a finding that respondent 2 was just the importer when the purpose of the agreement was to evade the taxes. And then Lord Sales, in relation to the disposal point, your lordships can see that at paragraph 6, the issue of dispose does not even arise, as right from the start, respondent number 1 was in charge of the car, since he had the car sent to his address on the first day and made all the arrangements for the insurance. The whole purpose of the scheme was to deprive the revenue authorities of a sizable amount of money which would have been payable otherwise. So, my lord, I would submit that that was the case that was being put before the learned magistrate. In the appeal proceedings, we make as a preliminary point or a preliminary observation in response to the appellant's arguments, why was the director appealing at all? He was not seeking a declaratory judgment from the Supreme Court for the Supreme Court to give guidance at the level of principle. He was asking the Supreme Court to do justice in the case under appeal. As the notice of appeal made clear, he was seeking to set aside the lower court's judgment, and the remedy was for the Supreme Court to deal with the matter as they deemed fit and proper. The response of the Mr. Lagesse to the appeal can be seen at page 602 to 613. That's his submission document, 602 to 613. And at page 605 is the most clear statement of how the respondents to the appeal, the defendants in the lower court proceedings, were putting the case. Your Lordships will see that at 605, paragraph 22, when the argument that was being advanced was that the magistrate had been entirely correct, applying sound principles of taxation and matters of statutory construction and the strict interpretation that was favoured. And reference was made to Mon Trésor milling, which referred to the statement of Mr. Justice Rowlett in the Cape Brandy Syndicate case. In other words, the respondents to the appeal, the defendants, were saying, yes, it was correct to apply the strict interpretation. Before the Supreme Court argument took place on the 21st of, before the Supreme Court, the argument took place on the 21st of May. The transcript of the argument appears at pages 661 to 752, and Mr. Bongali's argument is at page 661 to 722. The point he was making in relation to the tax legislation is that the scheme had to be interpreted in its context. And of course, he was submitting in the context also of his own written submissions. And at 721, just to go to this, because far from suggesting that the that the defendants were knocking at an open door, which I simply do not accept. At page 721, your Lordships will see in the middle of the page. So if I understand your case, is in fact respondent number one who has imported, who is using, and who has benefited from the vehicle. This is your case. That's right. That was the case. The submissions on behalf of the defendants can most clearly be seen at page 724, just over halfway down, is the court say that what your friend seems to be suggesting is the whole scheme was set up purposely to avoid payment of tax. And leading counsel for Mr. Lagesse, I take the argument to the appellant himself, who says that disposing is not in issue. This is paragraph 6 of their submissions. So if disposing was not in issue, it's apparent that the only thing that was in issue was the legality of the scheme overall. And we do not agree that the Supreme Court indicated either its disagreement with the director or agreement with counsel for the defendants. The court was doing no more than what any appeal court does. It was keeping an open mind before it retired to consider its judgment and look at the papers in detail, and judgment was reserved for 2 months. So far as the judgment of the Supreme Court is concerned, if I may just make some brief observations in relation to that, it's at pages 761 to 769, and the key point identified by the Supreme Court is at page 768, after citing the statement of principle from Permanent Justice Ribeiro in the Hong Kong Court of Final Appeal. And if I may, I know your Lordships will be familiar with the judgment, but we support and adopt the Supreme Court's reasoning. And as the Supreme Court noted, at page 769, it was an error of law in the way the magistrate had adopted his approach. And the Supreme Court went on to explain how the lower court should approach the position. Lords, it's also relevant to look at page 776, where one of the points that was being made by the director was that the 2013 amendment was irrelevant. That was ground 3 of the appeal, and that also succeeded on the basis of what was the true purpose of the transaction. But also, your lordships will recall at page 777, grounds 4 and 5 were the grounds that suggested that the magistrate had reached perverse findings of fact. And the Supreme Court agreed, but only to the extent that the magistrate had not based his assessment on proper legal principles. The point being made there, we would respectfully submit, is that the Supreme Court were effectively saying we are not going to substitute a conviction. The magistrate was wrong on those facts, but it's still arguable as to what the position is. So we submit the Supreme Court was clearly correct, and that the errors identified by the Supreme Court went to the very heart of the trial proceedings. The Supreme Court was right to quash the decision and also to order an early retrial. The routes to a retrial, as the board knows, are either under the Constitution or under the local District Courts Act legislation. The Constitution of Mauritius acknowledges in section 10 that, for example, it would not be, that's at page 1152, section 10. 1152, 10.5 deals with orders of retrials which do not raise any issue of double jeopardy. There is also 82, section 82.1 at page 1155, which provides the Supreme Court jurisdiction to supervise civil or criminal proceedings and make such orders and such writs and gives directions as may be appropriate. And section 92, the appeal provision, and section 96 at 1473. We submit that the decision of your lordship's board in Dosseruth, which is at page 1300, 1300, was correct, and Lord Hope's discussion at paragraphs 24 and 25 are clearly correct. And the reason why we submit that Dosseruth is right and correct in it to serious irregularity is because the board recognised the importance of flexibility on the part of the appellate court to do justice in any particular case. As Lord Hope noted, section 82.1 is in the widest terms, and section 96.5, serious irregularity, is to be given a generous construction. We do not accept that serious irregularity is to be equated with an irregularity that would lead to a finding of a nullity. That is to elide both the characterization of the failing and the consequence. The failing is the serious irregularity. The declaration that is made once a serious irregularity has occurred is for the Supreme Court to declare that the trial has been a nullity. This was similar to the position in England and Wales before the amendment of the Criminal Appeal Act, where there was the expression material irregularity. And material irregularity in England and Wales, before the present formulation of unsafe, material irregularity covered any misdirection in law. It was given a generous expression, and it's doing no more, serious is doing no more than excluding trivial errors, which presumably would not lead to any alteration of the lower court's conclusions. In this case, the irregularity was serious. We submit that the order for a retrial...
I'm sorry, Mr. Perry. Mr. Guthrie makes the point that both in the Constitution and in the specific provision, the power is a permissive power.
Yes.
And therefore he submits that this calls for some examination by the Supreme Court as to whether it should be exercised. Neither in the Director's notice of appeal nor in the course of the hearing is any mention made of the power to order a retrial, or much less any canvassing of the reasons that a retrial should be ordered. I know that you make the point, well, that can all be cured by today's proceedings, but is that not at least incongruous?
Well, but Lord, first of all, my Lord, may I accept that the power is permissive, because that is consistent with the case that we are making, that what is desirable is flexibility to ensure that justice is done. But, my Lord, then the question arises, suppose the Supreme Court had raised the question of a retrial, what possible argument could there have been to prevent it? Now, my learned friend says, oh, well, there are these arguments, the passage of time and the fact that Mr. Lagesse had been candid. In relation to the first point, the passage of time point is a consequence of appellate proceedings, and it is frequently the case that there is extensive delay, even in England and Wales, but that is not an impediment to the ordering of a retrial. The second point is, on the prosecution case, Mr. Lagesse had not been candid. He had been candid to the extent that he'd made self-serving affidavits and statements, concealing what in fact was the true position. And your lordships know, and this is the problem that is created. Once the Supreme Court say this decision cannot stand, the only fair resolution is to order a retrial. It's the only fair resolution for these reasons. First of all, the public interest demands for there to be a proper resolution of this case on its merits, because this was a matter of profound concern in Mauritius in relation to the abuse of this system. I've referred your lordships to the media articles. Yes. The second point, my lord, is the interests of the appellants, because what then is the position? The Supreme Court says, well, actually, there is a real suspicion here that you were guilty, but we're going to set aside the conviction and the acquittal and not order a retrial. And, my lord, what I would submit is that that would be an impossible situation. One way or another, this case has got to be resolved in the public interest and in the interests of the appellant. And if these arguments have any merit at all, your lordships are in the same position as the Supreme Court of Mauritius. I should correct one matter. I think in our written case, we dealt with the board's powers, and it's not in the bundle, but your lordships also have the power under the 1833 Act at section 13 to direct a new trial. So that's a freestanding order. So, my lords, what we would submit is there are only three possibilities before the Supreme Court. There are only three possibilities: dismiss the director's appeal, allow the director's appeal and substitute a conviction, which would not have been satisfactory given that the magistrate had failed to address the key fact, or set aside the acquittal and direct a retrial. And the reason why the retrial is fair is explained by the Somali pirates case at page 1334, because the Supreme Court made it clear that it was much fairer to order a retrial than to struggle to convict, to find facts that would lead the court to convict, because then there could be a fair trial. The public interest could be served by that, and any that lingers over these appellants should either be dispelled or it should be resolved. So that's Lamto, we submit, was clearly wrongly decided. Sorry, my lord, sorry.
What brings this question?
For my mic.
I'm sorry, my lord, I can't hear.
Yes,
My microphone was turned off, but I think it's back on again.
Yes, thank you.
Mr. Perry, we have seen how the double jeopardy provision in the Constitution springs either from a conviction or an acquittal.
Yes.
If the Supreme Court had simply set aside the acquittals as they did and not ordered a retrial, would the prosecution have been simply able to bring, if they thought fit and thought it was in the public interest to do so, fresh charges? Or was there some limitation issue which would by then?
Well, the answer, section 10.5 of the Constitution, which is at 1154. I'm not suggesting I know the definitive answer, because it's probably it would probably be a council case to determine it. But if you've been tried by a competent court or acquitted, you can't be tried again except upon the order of a superior court in the court of an appeal. But there may be arguments as to whether one possible argument around that, my lord, in favour of your lordship's observation, it's certainly an arguable point, is whether there was ever, if you look at the fundamental errors here, whether they were ever in real jeopardy, because there is a line of authorities, for example, in England and Wales, as to whether you've ever jeopardy. But it looks as though a more conventional reading would be that 10.5 operates in harmony with 82 and also 96.5. But, my lord, the and the retrial provisions in England and Wales, which have become more liberal as time. In England and Wales, it was only possible to have retrials in fresh evidence cases. It's now every case where a conviction is quashed, the Court of Appeal has power to order a retrial, because it has been recognised that it is important that justice is not only done, but it's seen to be done. And significantly, there is no proviso under Mauritian legislation. So far as the Mauritian authorities are concerned, my lord, just one sentence in relation to that. The Mauritian authorities, you can read them all for hours on end, but you will never discern a principle that emerges from any of them as to the meaning of serious irregularity. They simply do not address the point, and they do not assist on the issue of principle. So far as the case against Mr. Seeburrun is concerned, the case against him was clear. The scheme was a sham. Mr. Seeburrun was a pret non, was the prosecution case. And I've already pointed out the position where the prosecution clearly set out its case. And as the Supreme Court noted, there were real arguments here as to the true import of the scheme. And for the reasons we've set out in our written case and we've submitted today, we would submit and respectfully invite your lordships to conclude the decision of the Supreme Court was right. There was no unfairness in the hearing in the Supreme Court, and even if the arguments had been heard, what would the conclusion have been in reality? And in any event, your lordships have heard the arguments, and if there was unfairness, which I don't accept, your lordships can cure it. The appellants were aware of the case they had to meet, and the one they do have to meet at the retrial. The Supreme Court did have the power to do so, was right to order a retrial, and the retrial will be fair because the facts are agreed and the documentation means that the oral evidence has less significance because the true analysis is based on the contemporaneous materials produced before the intermediate court. For these reasons, we would invite your lordships to dismiss the appeal, and unless we can assist your lordships further, those would be our submissions.
Thank you very much indeed. Mr. Director, do you wish to make some submissions? Mr. Director?
Yes. Yes, my lord. Thank you very much. I think Mr. Perry has covered all the three issues before your lordship with the eloquence for which he is known. If your lordship allows me, I'd just like to make two very brief points. I've listened with interest the debates regarding Section 82(1). There is maybe I'm adopting a slightly different approach, but I would simply like to add that Section 82(1) is not unique to Mauritius. Similar versions of Section 82 exist in constitutions of many former British colonies, commonly referred to as the Westminster model. I mean, the country next door, Botswana, is an example where you have similar provisions. And it's precisely to enable the give supervisory power to a superior court to make such orders, issue such writs, and give such directions. The Section 82 also is not the only section in the Mauritian Constitution worded in such broad terms. Section 17 of the Mauritian Constitution, which is also a provision which has similar versions in the Westminster model constitutions, secures the enforcement of fundamental rights and freedoms. I would describe these two provisions, my lord, as core provisions, which go at the very heart of a written constitution like ours, and reflect the philosophy of that constitution. In the case of Dussurat, at the risk of repeating the passage which was already brought to the attention of your lordship at page 1309 of the electronic version, I just quickly read that what Lord Hope has pointed out, that it is not Section 96 must be read together with, of course, Section 82, which is a constitutional provision, which provides that the Supreme Court may make such orders, issue such writs, and give such directions as may consider appropriate to ensure that justice is duly administered by any such court. It is not necessary for proceedings for constitutional relief to be brought under Section 17 of the Constitution to enable the Supreme Court to exercise this power. It is available to be exercised in any proceedings which are brought before that court, including those of Section 92 of the Act. My lords, at paragraph 26 of that judgment, Section 17 is referred to, and the words, the broad terms of that section is mentioned there. All that I want to point out is that these two sections, they are essential to the administration of justice and the maintenance of the rule of law. Not only do they secure the enforcement of fundamental rights and freedoms, but also ensures that constitutional norms and safeguards permeate throughout all layers of our judicial system when and if necessary. The proposition that Section 82 should be given a restrictive meaning is, in my humble submission, an untenable one, because those are in the provision would come to confront different situations to ensure that justice is duly administered. This was the first point I wanted to mention, my lord. The second point I want to mention is with regards to the argument that the appellate number 2 was misled. My lord, this case, the inquiry regarding this case was started by the revenue authorities on a case of tax evasion, and the case migrated to the police authorities. And as your lordship would know, that as regards an inquiry, there's no prescriptive rule as to how the inquiry would unfold. And in this particular case, the inquiry unfolded and that it was found that it involved many more players, that there was a scheme designed to defraud the revenue authority. There were dozens of cases with the same modus operandi to evade payment, and it was more appropriate for the police to inquire into the case. If I may now take your lordship to page 790 of the electronic version, 790, I'd just like to point out question 60. Where the right, I just get my pagination correct, my lord. Yes, where question 60 was put to the appellant number 2, Mr. Seeburrun, and so the question is phrased in these following terms. The police has reason to say that in December 2010, you conspired together with Mr. Lagesse and Mr. Tulsi to make Mr. Lagesse avoid paying duty on the importation of that Mercedes car, to cause the car to be imported in your name, while Mr. Lagesse is not a returning resident and not beneficiary of duty concession. In doing that deal, a prejudice of 7 million and something rupees has been caused to the Mauritius Revenue Authority in terms of tax. What have you got to say? And of course, in a list of questions that were put to him, he chose not to answer, preferring to rely on the self-serving affidavits. But my point here is that right at the very outset of the inquiring process, he was aware what case he had to meet, and he was assisted during that during those statements and in court by counsel. I think it would not be his contention that he did not know which case he had to meet, does not stand. Those are the two brief points I wanted to point out, my lord. I know time is of essence, but I am happy to answer any questions that your lordship may wish to ask me. Thank you very much.
Thank you very much indeed, Mr. Director. I take it, no, Lord Hamblin.
May I just ask either Mr. Perry or Director one question? Relates to the supplementary note and the Criminal Appeals Act and the wider wording in relation to retrial orders in that act. Is there anything either you wish to say about that point?
Mr. Perry, first of all, would you like to say anything about that?
Lord, may I just say this, my Lord, that we submit that has no bearing on the precise issues with which we're concerned under the Intermediate Courts Act. But what the legislation is recognising is the value of the ability to order a new trial in the interests of justice. And this is all consistent with the submissions that we have been making, rather than inconsistent with our submissions.
Mr. Director, is there anything you want to say about that?
Yeah, the appeal before the Court of Criminal Appeal come from the assize cases under the Criminal Appeal Act, and those cases are tried by under the jurisdiction of the Supreme Court. So in that sense, where there are issues of material irregularity or fresh evidence have come to the surface, because in view of the seriousness and those cases that go to before the Supreme Court are reserved for the most serious cases, and it is only in those very limited and exceptional situations that there can be a referral back for a case to be heard again, and exceptionally where there is fresh evidence which did not arise, which had arisen ex improviso.
Nothing further then. Thank you very much indeed. Mr. Guthrie.
My Lords, I think my microphone has just been turned on, yes. My Lords, can I begin by returning to Lord Briggs's question, which he asked both me and Mr. Perry about the possibility of a fresh prosecution. My Lords, I think the answer is indeed in section 10, subsection 5 of the Constitution, which is at page 1154 or 1155, which provides that no person who has been tried by a competent court for a criminal offence and either convicted or acquitted shall again be tried for that offence or for any other criminal offence, except upon the order of a superior court. So unless there was an order from the court for a retrial, there couldn't be a fresh prosecution. My learned friend, Mr. Perry, has, and I agree with him, identified the two routes to a retrial as being in section 96.5, which we've looked at in detail, and section 82.1 of the Constitution. My Lords, I heard his suggested construction of 96.5 as being in some way equivalent to the English provision which deals with material irregularity. My Lords, that with respect ought to be rejected outright. If one looks at section 96.5, one sees how it is expressed. Lords, I hesitate to take you to it again, but the reference is 1474 or 1475. And the subsection reads, where on an appeal under section 92, the Supreme Court is of opinion that serious irregularity has occurred, it may declare the trial to be a nullity and order a fresh hearing. So in other words, the fresh hearing is dependent upon the prior declaration that the trial has been a nullity. And it is quite impossible to separate the two concepts. My lords, on that question of serious irregularity, can I ask you to return one more time to the case of Seeburrun, because that expression of serious irregularity was considered by Lord Hope in a particular context. And I think it's important to see what happened. First of all, having said, and we certainly don't disagree with the proposition that Section 82 is in the widest terms. However, when the court at paragraph 25 goes on to consider Section 96, subsection 5, and the possibility of a serious irregularity, it goes on, it was open to the appellant to contend that there had been a serious irregularity at his trial if, as he contends, he was convicted on the false assumption that the incident could not have happened. And then the next words are important. The constitutional guarantee of a fair hearing in Section 10(1) requires that a generous construction should be given to the expression serious irregularity, but the appellate court was not asked to consider that. Now, Lord, the context of Section 10(1) of the Constitution is, as we can see from the Section 10(1), which we just looked at Section 10(5) on page 11545. 10(1) is on the previous page, and that is one of the fundamental constitutional provisions. Where any person is charged with a criminal offence, then unless the charge is withdrawn, the case shall be afforded a fair hearing within a reasonable time by an independent and impartial court established by law. And what Lord Hope was saying was that given the constitutional guarantee to a defendant of a fair hearing, then in an appeal by him, then the concept of a serious irregularity should be given a fair hearing. He was certainly not considering the situation of an appeal by the Director of Public Prosecutions in that case. The question simply didn't arise. And we submit that Section 82(1), which it's not a restricted construction, it is there to protect the administration of justice. And in our submission, part of the administration of justice is the laws which have been passed by the legislature to provide for the circumstances in which a retrial should take place. Oh, I'm so sorry, Lord Sales.
Yes, Lord Sales' question.
I'm so sorry.
Sure. But the phraseology in Section 96(5) is serious irregularity. Is that not the test to be applied, whether it's an appeal by the individual or by the state? And so why, if that's right, why do Lord Hope's observations about the width of the meaning of that phrase when it's the appellant, the individual who appeals, not apply equally to cover the position when it's the state that appeals?
Well, because he's using the basis for the broad construction of serious irregularity to, in the context of Section 10(1), which only applies to the appeal by someone who alleges they have not received a fair hearing under Section 10(1), the fair hearing by an independent and impartial. And it only applies to a person who has been charged with a criminal offence.
Yes, thank you.
Well, Lords, the next point I was just going to make, a very brief point on Section 82(1). I don't consider it's a question of a restrictive interpretation, but it is there to ensure that the court can make such orders as it considers appropriate for the purposes of the administration of justice. And the legislature in Mauritius has provided in the Intermediate Courts Act for particular circumstances in which a retrial may be ordered. And as my Lord Hamlin observed, they are different in the case of appeals from the Intermediate Court to the Supreme Court, the case of appeals from the Supreme Court to the Court of Criminal Appeal. Lord, that's all in relation to the first point, which I argued. The question whether the magistrate's decision was right, my learned friend went through the transaction and various of the documents in some detail. The fact is, though, that that is really more a matter of prejudice than a matter which goes to the basis upon which this decision should be, this appeal should be decided. The fact is that the documents that he took him to, which evidenced the importation or the payment of the price for the car by the appellant, Mr. Lagesse, all of that was common ground. He referred to documents emanating from Mr. Toolsey. Mr. Toolsey was roundly accused by Mr. Lagesse of fraud, and indeed he invited the police to investigate the part that he played. My lord, we can see that in Mr. Lagesse's statements to the police, he produced the documents upon which Mr. Perry now relies to demonstrate, for example, that he paid for the insurance, the shipping, and so on and so forth. None of that was in dispute. The ownership, I'll come to in a moment, but to brand a transaction as a sham somewhat begs the question, because it was accepted by the appellants that what they had arranged was not a sham in a criminal sense, but it was an attempt to use this scheme for the benefit of Mr. Lagesse. Their point was that this was not against the law. And it is wrong to suggest the magistrate didn't grapple with that at all. If one goes to page 605, one sees that there's a reference to the submissions which were made to the magistrate about this. What this is taken from the respondents, the first respondent's skeleton argument in the Supreme Court. And the quotation is set out from the judgment. The prosecution submitted that the unlawful act is the fact that accused number 2 used the benefit of the concession on duty and taxes when importing a car which was entitled to someone else's benefit. However, the short answer to this is, while it may be true that this is the case, it is nevertheless not unlawful. There is no restriction or condition on how the car so imported under the returning scheme should be used, or as regards its possession as at the date of the offence. There is simply no restriction to the effect that he could not allow someone else to use and enjoy the car. I come back to the point which we make on the merits, that the magistrate was under no illusion whatsoever as to the purpose and the overall intention of the scheme. He, however, asked himself the correct question as to whether or not it was in breach of the law so as to find a conviction for a criminal conspiracy to evade tax. And he considered that it could not, because the words and the restrictions on the returning scheme did not apply to what had happened in this particular case. Your lordships have my submissions about that. So far as the ownership of the car is concerned, and I noted this morning Lord Hamlin's question that there was an anterior question as to whether or not the first or the second dependent was the owner of the car. Lords, it appears to have been accepted by the Supreme Court that the owner was indeed Mr. Seeburrun, because we see at page 696 in the transcript Mr. Justice Hamout saying, within the meaning of the law, he was the owner as far as everybody is concerned. That's at the top of the page. And Mr. Bangale for the Deputy Director says, but my lord, and the judge says, it was registered in his name, wasn't it? And then Mr. Bangale says, yes, the facts of the case show that when the car, when it came to Mauritius, came in his name. The documents that the Revenue Authority showed it was clear under his name. Therefore, that would allow him to benefit from, and he's about to say, the concession. Not only that, but it was registered with the NTA, who are the traffic people. And Mr. Bangale says, yes. And he says, no difficulty with that, my lord. And in the judgment, in fact, the Supreme Court never says that the owner was the first appellant. It appears to say, simply, you look at the whole of this, it's a sham. The intention was to avoid tax. It doesn't grapple with the distinction between evadance and avoidance, but uses the word circumvent, and then leaps to the conclusion that that is a criminal offence. As we say, the magistrate's approach to that particular issue was the right one. Lord, finally, on the point of what your lordship should do in the event that you agree with us that it was wrong for the court, which never mentioned any of its powers or discussed them with counsel, to have reached the conclusion it did without any apparent exercise of a discretion at all. Lord, I've already made our fundamental point, which is that it would be wrong to, so to speak, if you find the hearing was unfair in that or any other respect, to do anything more than to set aside the judgment. But it would seem, with respect, to be unrealistic to, after the passage of time, in particular, simply to ignore those matters and suggest that the only possible conclusion would be to order a retrial. I would respectfully ask your lordship simply to set the judgment of the Supreme Court aside and suggest that it would not be appropriate to remit the matter now, certainly not by your lordships, to order a retrial, as I think Mr. Perry suggested you might do, but also not to remit the matter to the Supreme Court now, because the approach of the Supreme Court was can be seen to be fatally flawed. In those circumstances, the ordinary appellate conclusion would be to set the judgment aside. That's what I wanted to say in reply.
Thank you very much indeed. Mr. Duval, you have 10 minutes if you wish to avail of them, but don't feel obliged to.
Yes, my lord. Firstly, the best part of the first hour of the oral submission for the respondent was devoted to the facts of the case. So much so that one could not be blamed for thinking that the issues arising from this appeal are mainly issues of facts. We do not accept that. In fact, even before the Supreme Court, the issues were not mainly about issues of facts. I stress that before the Supreme Court, it was never suggested that the judge, the trial magistrate, had misinterpreted the case of the prosecution. It was not suggested that he had got the facts completely wrong. The facts were hardly disputed. The reproach was that he failed to draw the right inferences from the facts that he had found proof. And my lords, if we, on many occasions, we have heard that the evidence shows that Mr. Lagesse had exclusive possession of the car. That is something which the second appellant does not accept and reiterates that the findings of facts under count 5 are unchallenged and are inconsistent with that statement. Thirdly, we are told that the respondent does not accept that there was a shift from trial to appeal. The fact is that the Supreme Court did find that there was, no, it did not find, observe during the hearing the shift, but then make no finding in the Supreme Court. Fourthly, we are told that the only fair result is a retrial. Again, we do not accept that. Under our system of law, the prosecution had carriage of proceedings at trial. It sought to prove a case, which was that the second appellant was the importer of the car, had imported the car with the intention of disposing of that car in favor of Mr. Lagesse, and therefore ought to have paid tax. By the time we went to appeal, Mr. Lagesse had become the importer of the car, so that the issue of disposal was no longer of any relevance. The prosecution had sought to make a case that it did not prove, and then tried to make another case before the Supreme Court. It would not be fair to allow them a second bite at the cherry, so that they may address the inconsistencies between those two cases in a new trial. Finally, my lord, it is said that the second appellant was not misled from the outset. The outset, my lord, was the inquiry of the customs. And there is evidence that as far as the custom was concerned, there was a custom offense. There was nothing about conspiracy. And the offense which Mr. Seeburrun was told he had committed was to dispose of this vehicle without paying the duties that had to be paid upon disposal. Proof that he was misled, my lords, is that even before the case was referred to the police, Mr. Seeburrun had gone to court, had initiated civil proceedings in which all the facts, or most of the facts on which Mr. Perry GC have relied, were disclosed by Mr. Seeburrun in his affidavit even before the police was seized of the matter. This clearly indicates, my lord, that he was misled as to what the case he had to meet from the outset. That is all, my lord.
Very much indeed, Mr. Duval. I'm grateful to all of the council who participated, and no doubt to those who assisted in the preparation of this difficult and very interesting case. The board will take time to decide what advice it will humbly tender to Her Majesty, and the court is now adjourned. Thank you.